Welcome to the Planning Podcast. I'm Richard Kimblin and I'm here to introduce Jess Allen and the topic of planning and habitats. Jess is going to take us through the how did we get here of habitats issues, the way in which the Habitats Directive has been fundamental to so many of the really major issues which planning faces today. If you want to know what it is that brought about our present approach to those protected areas which have such a substantial influence on the way in which we conduct planning in key areas of both England and Wales, then this is a podcast for you. So, Jess, hello and good afternoon to you.
Hello, Richard. Good afternoon.
Now then, I've got in front of me a document which has the rather forbidding title, Exclusion Zones. Why are we bothered about exclusion zones? What's the topic?
So I think another key concept that's useful to understand before we get to understanding exclusion zones is European sites, because when we're thinking of exclusion zones, they are around European sites, and European sites are effectively protected sites that have been designated in the UK pursuant to the implementation of EU law on nature conservation. And the current legislation that implements that law and has been retained or is still in force post-Brexit is the Conservation of Habitats and Species Regulations 2017, Regulation 8 of which defines European sites as including, firstly, a special area of conservation, which we'll get onto, secondly, a site of community importance, which has been placed on a list under the Habitats Directive, which again we'll get onto, and thirdly, an area that's classified under the Birds Directive, which we call special protection areas. And again, we'll define that. But those are the three principal types of sites that we designate or are designated in the UK under the auspices of European Union law.
And so what we're doing here then is identifying those SPAs and SACs which are European sites around which it might be necessary to be particularly careful about development proposals because there might be a likely significant effect on them. And we're going to have a look at those and we're going to call them exclusion zones because it might be that some plan or other has decided that we're not going to be able to do something within those zones. And you've just set out the origin in European law of those, which we've retained as retained European law. So nothing really changing post-Brexit. And we're going to have a look at where that has all led us.
Yes, and I think it's also interesting at this point, as this is a podcast that's going to chart how we got to where we are now. I think it's quite important to understand the very origin of all of this, and that dates back to 1979, and that was with the signing of the Berne Convention on the Conservation of European Wildlife and Natural Habitats. And now that's an international treaty, not a European Union law directive. It's a treaty that was adopted under the auspices of the Council of Europe, to which many European countries are a state party, including the UK, but it's also been adopted by the EU as an international organisation. So the UK, irrespective of Brexit, is a party to that convention, irrespective of the EU law that implements it. And the Article 1 of the Berne Convention, it sets out three principal aims. The first is to conserve wild flora and fauna and natural habitats. Secondly, to promote cooperation between states. And thirdly, to give particular attention to endangered and vulnerable species, including those that are migratory species. And I think what is particularly noteworthy from that convention is Article 4, which is what indicates that each contracting party shall take appropriate, necessary and legislative and administrative measures to ensure the conservation of habitats of wild flora and fauna and the conservation of endangered natural habitats. Secondly, it actually states explicitly that contracting parties in their planning and development policies shall have regard to the conservation requirements of the areas that are protected, so as to avoid or minimise as far as possible any deterioration of those areas. And then there are various other statements there around giving special attention to protection of areas that are important for migratory species and to undertaking coordinated efforts for the protection of natural habitats. And it's really in the spirit of encouraging the contracting parties to cooperate that the EU sought to implement that treaty in a harmonised way, rather than having all member states, including the UK, adopting their own different legislation. And the EU adopted 2 core directives to implement that treaty. The first was Council Directive on the Conservation of Wild Birds, that's known as the Birds Directive colloquially, and the Council Directive on the Conservation of Natural Habitats and of Wild Flora and Fauna, which is colloquially known as the Habitats Directive, which were adopted circa 1979 and 1992. And one way in which the directives seek to protect European flora and fauna and the habitats is through, as we've discussed, the designation of SPARs, Special Protected Areas, and Special Areas of Conservation, or SACs, which together form this network of protected sites. And those directives were then implemented in the UK through the Wildlife and Countryside Act 1981 and the Conservation of Habitats and Species Regulations, firstly adopted in 1994.
That's fantastic. So that's where it all comes from and where it all lands up domestically, including in the 1981 Act and some regulations in 1994, which have been amended since then. But that's the foundation. A convention, then directives transposed into domestic legislation, which, as we've identified, we've still got. And we can then think about, can't we, the extent to which they provide protection?
Yes, absolutely. And I think it's helpful at this point, I think, then to drop down to the European directives level, because in those directives, they set out quite explicitly the ways that the EU member states, which the UK was formerly, had to protect and manage those protected sites. In relation to SPARs, Article 3 of the Birds Directive indicates that member states shall take what they say are requisite measures to preserve, maintain, or re-establish a sufficient diversity in areas of habitats for all the species of birds referred to in that directive. And Article 3.2 states explicitly that those measures include primarily the creation of protected areas, so SPARs, the upkeep and management in accordance with the ecological needs of habitats inside and outside the protected zones, the re-establishment of destroyed biotypes and the creation of biotypes. And then when we think of the SACs under the Habitats Directive, Article 6.1 states that member states shall establish the necessary conservation measures involving, if needs be, appropriate management plans specifically designed for the sites or integrated into other development plans, and appropriate statutory, administrative, or contractual measures. So both directives refer to the adoption of measures, but in quite broad terms, really. And I mean, the European Commission note on Article 6 of the Habitats Directive gives a bit further guidance on statutory measures, administrative measures, and contractual measures. I won't necessarily set out what they say, but they are quite broad in their scope and they're quite complementary in their scope. And I think that's really then what brings us to these exclusion zones within which there is a presumption against development.
Now, I think about the first such big example of trying to sort out how to deal with these directives, the designated sites, and what can happen around them. I think of Dilly Lane. And if I mention Dilly Lane, does that mean anything?
Dilly Lane is an area for which there were applications for the construction of 170 houses, associated works in the form of improvements to a footpath and creation of recreational green spaces, otherwise known as suitable alternative natural green spaces, or SANGs. And that area was the subject of the decision in Hart District Council and Secretary of State for Communities and Local Government.
So Dilly Lane turned up in the High Court as Hart. So what happened in Hart?
So Hart concerned this development around Dilly Lane, which was in the vicinity of the Thames Basin heaths, which was classified as an SPA, a SPA, for 3 species that had been listed. So those were the nightjar, the woodlark, and the Dartford warbler. In total, the SPA covered around 8,400 hectares, so very large, and also not too difficult to be within the vicinity of it, I suppose. But the proposed development area was around 1.5 kilometres south of the nearest point of Hadeley Heath, which was a heathland site of special scientific interest, a different type of protected area, not a European site. But that SSI was a component of the Thames Basin Heaths SPA, and similarly other SSIs, which also were within the SPA, were within 5 kilometres of that development area. At that time, there had been strategic guidance that was provided by Natural England, which was called the Thames Basin Heaths Special Protection Area Mitigation Standards for Residential Development. The purpose of that guidance was to provide advice on the in combination impact of housing development within 5 kilometres of the SPA, and that had been subject to a considerable debate, notably in the context of the South East Plan examination in public. And so the question arose in the Dilly Lane decision whether a plan or project was likely to have a significant effect on the SPA, whether that was to be assessed with or without taking into account any mitigation measures. And in this case, that referred to the suitable alternative natural green spaces, the SANGs. So that was the question for the court. And in that case, the High Court found that there was no absolute legal rule that mitigation measures should be disregarded in assessing the question of whether a project or plan was likely to have significant effects. And the judge considered that, in his view, there was no sensible reason why features which were incorporated into a project should be ignored at the initial assessment stage, merely because they're directed at combating the likely effects of the project. Now, that decision was then subsequently considered by the European courts in a decision referred to as People Over Wind, which actually said quite the opposite. That decision was several years later, and in that case, the European court had actually said that the very presence of any mitigating measures in a proposal presupposed that it is likely that the site is affected significantly, and that consequently such an assessment should be carried out. And that assessment, we've not referred to in this podcast yet, but that assessment is called an appropriate assessment, and that provision is made both within the European directives but within the UK implementing legislation for the undertaking of an appropriate assessment in order to determine whether any plan or project is likely to have significant effects on the environment on these European sites. That assessment is the process by which we determine whether or not there are likely to be significant effects, and if yes, what measures might be necessary to be tailored to those different European sites and the impacts that might be had in this judgment.
So we've got their Hart from Dilly Lane saying one thing, then we've got People Over Wind saying another thing. So has the court had an opportunity to decide whether or not it wants to jump Hart or People Over Wind?
Yes, and there have been several decisions where UK courts have followed the People Over Wind decision. One of those is Canterbury and Secretary of State for Housing, Communities and Local Government, that's Canterbury County Council, in which DoveJ considered the decision in People Over Wind, and he concluded that the position of the European Court on the proper interpretation of Article 6.3 of the Habitats Directive, which is the article of the directive relating to appropriate assessments. He said that the proper interpretation is clear and that taking account of mitigation measures at the screening stage is illegitimate. His Lordship stated that it was a low threshold for triggering the need for an appropriate assessment due to the need for a strict precautionary approach. Interestingly, there was a decision which cast some consternation, which was the decision of Sir Ross Cranston in R. Langton, or R in the application of Langton, and the Secretary of State for Environment, Food and Rural Affairs, in which his lordship drew a distinction between measures that are integral to a proposal, and saying effectively that if a measure is integral to a proposal, then it should be taken into account at the screening stage, irrespective of whether it has a mitigating effect by virtue of the very fact that it is an integral feature. But the prevailing view in decisions of the UK courts has been that mitigating measures should not be taken into account. And in fact, there was PIN's guidance issued not long after the People Over Wind decision, which guided inspectors to, where possible, where there are measures which can be disaggregated and properly were described as mitigating measures, to leave those out of account at that initial screening stage.
Okay, so that's the vexing question of designed-in mitigation. We've already identified Hart and Dilly Lane as one location of interesting litigation in this respect. What about Wealden? Wealden seems to pop up all the time. What's been going on in the Weald?
Yes, so there were several interesting cases involving Wealden District Council, in particular involving Ashdown Forest, which is designated both as a spa and as a SAC. It's part of a complex of heathlands in southern England that support breeding bird populations, and which have been listed in both European and UK legislation. And the first Wealden case of interest is from around 2015, and that involved a challenge brought by a developer against a policy that had been adopted by Wealden District Council in the Wealden District Core Strategy Local Plan, which required all new development within 7 kilometres of Ashdown Forest to provide suitable alternative natural green space to mitigate impact of increased visitors to the forest. A habitat screening assessment had been prepared in conjunction with the draft core strategy, and that assessment had considered the question of whether the 7-kilometre zone would avoid the risk of harm to the Ashdown Forest, thus avoid the need for an appropriate assessment pursuant to the Habitats Directive and the conservation regulations. However, the issue in that case surrounded the fact that it wasn't the function of that assessment to consider alternatives to a 7-kilometre zone, and it did not follow that the conclusions from that assessment, it did not follow that there were no alternative means of ensuring the Ashdown Forest spa and SAC were protected. So in those circumstances, the case came before the High Court and subsequently the Court of Appeal, and the Court of Appeal reversed the decision of the High Court, finding that the policy that had been adopted was adopted in breach of the duty that exists under Regulation 12 of the Strategic Environmental Assessment Regulations relating to the assessment of reasonable alternatives. So effectively, there was no consideration of alternatives to the 7-kilometre zone. That was the only option that had been considered as a way to protect the spa and SAC. And the court found that, in fact, there should have been a consideration of alternative possible measures to that zone.
Lots going on around the Ashdown Forest, both impacting on local plans and also on specific applications and appeals, and all to do with the extent of and the impact of an exclusion zone around a European site, in this case an SAC, a SAC.
Yes.
And all of which keeps lawyers gainfully employed.
Exactly.
Has this played out in any other way? Is there any other way in which this question of excluding and European site having an effect well outside of its designated boundaries, is there any other way in which it's playing out and we see in fact how the directives have yielded a big effect in what we do day to day?
There was a subsequent decision, again, involving Wealden District Council. In this case, it concerned a challenge actually brought by the District Council against a decision of the Secretary of State by his appointed inspector to allow an appeal in the area of Ashdown Forest. And it was an appeal against a refusal of planning permission for residential development and associated works. This decision was 1 or 2 years after the first Wealden case and the first judgment that we discussed. In that case, the application had initially been refused by the District Council on the basis that the proposed development, both alone and in combination with other plans and proposals, would have had an adverse effect, it said, on the integrity of the Ashdown Forest spa and SAC, and the edge of the forest was around 2.4 kilometres from the site in that case. The inspector had found in his decision that contributions towards a strategic access and management and monitoring strategy would have mitigated likely significant effects on the spa and SAC arising from nitrogen deposition. However, there was no scheme, it was found, for the reduction of nitrogen deposits by heathland management, and the court found that the inspector had not given proper consideration to evidence that the council had adduced, which raised a number of concerns about heathland management as a means of mitigation. And so in that case, the second case, Langje held that the inspector had actually made a factual mistake in assuming that heathland management to mitigate nitrogen deposits was part of the SAMS projects to be funded in part by the proposed contribution. So in that case, the decision of the inspector was found to be mistaken. And whereas in the first case, the court said, well, actually, the zone was only one of several options that should have been considered, potentially suggesting, one could say, that there may have been more appropriate measures that would have perhaps restricted that zone of exclusion. In this case, actually, we see that a decision which concerned a site 2.4 kilometres away from the Spa and Sac was still affected by the European protections, because here it was found that the SAMS project wouldn't have been a suitable mitigation, and therefore the decision was overturned on that basis.
Already we've had 2 Wealden cases. Is there a third for a hat trick?
There is a third, and again, now this one was brought by Wealden District Council. This was, again, 1 or 2 years after the second case we looked at, and in this case, Wealden District Council brought a challenge against the joint core strategy that had been prepared and adopted by Lewis District Council, together with the South Downs National Park Authority, which in part related to the manner in which impacts on the Ashdown Forest, Sac and Spa had been assessed, in particular as regards nitrogen dioxide pollution from traffic. What was interesting in this case is that Natural England had given advice which stated that effectively if the joint core strategy would give rise to an expected increase in traffic of a certain amount, and that was either by number of cars per day or by a percentage increase in traffic compared to that predicted at the end of the core strategy period, then the advice was it would have no likely significant effect on the SAC or SPA, and no appropriate assessment would be required. So there's a statement, a piece of advice from Natural England saying, in this circumstance, no appropriate assessment would be required. And so when the proper assessments were carried out, it was found that the joint core strategy was predicted to give rise to a lower number of cars per day, or lower increase than that suggested by Natural England. And so it was concluded by Lewis District Council and the National Park Authority that it would not be likely to have a significant effect on the SAC or SPA. The problem here was that the advice given by Natural England and the approach taken by Lewis District Council and the National Park Authority didn't pay attention to the fact that a neighbouring plan, the previously adopted Wealden core strategy, had also predicted traffic impacts on the same A road. So it was in particular around a particular A road. And in that case, the judge ruled that in assessing the joint core strategy, Lewis District Council and the National Park Authority should have considered the traffic impacts of both plans, because in combination, when applying the screening threshold, it would have been exceeded and an appropriate assessment would have been necessary. It was found in that case that because of erroneous advice that had been given by Natural England, which was found to be actually Wednesbury unreasonable, the judge then quashed certain relevant policies in the joint core strategy. And in doing so, the judgment was rather critical of the position that had been taken, that there was no need to carry out an express in combination assessment in relation to plans and projects which alone had environmental impacts that fell below a particular threshold. So it was an interesting third case to that trifecta, because it really touched on the impact that different plans and projects can have in combination, and the need to, in certain cases, consider the in combination effects of different plans or projects and not just focus exclusively on one plan or project in question.
Excellent. Wealden contributing for a third time then to our understanding of how these things work in practice, and all, as you've explained, deriving from the same strict protection and the way in which those strict protections are manifested in respect of planning decisions in respect of plans or projects. What about nutrient neutrality?
Nutrient neutrality, when we're talking about nutrients here, we're talking about nutrients such as nitrogen and phosphorus, which provide nutrient for plants and animals and required for them to grow. And they occur naturally in ecosystems, but human activities can really increase the presence of those nutrients in our environment, and particularly in our water. So the sources of excess nutrients are generally specific to a particular site, but they're known to come from, in particular, wastewater treatment works and agricultural pollution. And an excess of those nutrients can be damaging in the environment because it can lead to algal blooms in rivers and lakes. And interestingly, in 2019, there had been a ruling by the Court of Justice, the European Court of Justice, in what's known as the Dutch nitrogen case, which established that any additional nutrient loading to European sites, and particularly to those which were already in an unfavourable condition, would not be permissible under EU law on nature conservation. So in light of that judgment, Natural England issued advice to local planning authorities in England in 2019 and to a further 42 local planning authorities in 2022, which highlighted to them that a number of sites in their areas were protected sites, were European sites. They were European sites that were in unfavourable condition due to excess nutrients, and that extra wastewater from new housing developments could make that situation and that condition worse. So the idea of nutrient neutrality comes from the fact that it's a way, essentially, in light of that European judgment, a way of ensuring that a plan or project does not add to existing nutrient burdens, and ultimately seeks to ensure that there's no net increase in nutrients as a result of a plan or project, in this case, in a housing development. The idea is that where nutrient neutrality is obtained, any adverse effect on the integrity of a European site alone and in combination can be ruled out. But the problem that we have seen since that guidance was given and the concept of nutrient neutrality came into being is that it has slowed down housing delivery across a number of local planning authorities because there are limitations to mitigation opportunities, particularly insofar as developers are able to implement mitigation measures themselves. One of the primary solutions to date has been to buy up tracts of productive agricultural land and repurpose that land, and so as to provide a mitigation that cancels out any additional nutrient pollution from residential developments. But the problem with that approach is twofold. Firstly, it raises a risk of conflict with policy around the protection of best and most fertile agricultural land, or effectively taking out of production agricultural land, because the idea is that it's the productive agricultural land which is producing the nutrients and the runoff which is causing the issue. It's not agricultural land that's not in use. And secondly, there's also a conversation around the effect that has on the resilience of the UK food system. Again, by taking out of production agricultural land, there's increased reliance on agriculture and agricultural land abroad, and the effects of that reliance are really brought into focus by the supply shortages we've seen in recent years in the pandemic, in the light of the Russia and Ukraine war. So there are issues around achieving nutrient neutrality, and the mitigation opportunities are rather limited. In the last few years, at least, Natural England has introduced what it's called the Nutrient Mitigation Scheme, which operates similar to SANGS in that developers can purchase nutrient credits as a form of mitigation. But to date, only one of those mitigation areas is operational, and that's designed to mitigate the impact on the Teesmouth and Cleveland Coast Spa and Ramsar sites. So it's not a widespread scheme. It's not available in all areas of the country, not available for all housing developments at this stage. And it's really for that reason that in August of last year, an amendment was tabled to the Levelling Up and Regeneration Bill, which sought to address the issue of nutrient neutrality. It would have required local planning authorities to assume that nutrients in wastewater from new developments would not adversely affect European sites. But that, as we know, that amendment didn't go through. And as it stands, the position remains as it was. So there are concerns around how to achieve nutrient neutrality. And of course, there are a lot of conversations going on as well around the proper use of sewerage outfalls and the effect that that is having on water in our natural environment. It's understood that this isn't a problem just from housing developments. There are various contributors to excess nutrients in waters, and a big one of those is caused by wastewater treatment work. So a lot of unsolved issues, really.
So going back to our exclusion zone topic and the directives which you explained to us right at the outset, the common theme really is certainty, isn't it? That decision makers have to be sure that that which is happening around the designated area isn't going to adversely affect what's contained within the designated area, such that its conservation status is going to be affected, or that it's likely that it would be affected.
Yeah.
And this is why we get to all of these issues. It all derives from the same concept.
Yes, exactly. And it's interesting because it's one of the few areas where we do see in UK law, at least, the implementation of the precautionary principle, which is a well-established environmental law principle internationally and particularly within the EU. This is where it really comes to bear in UK law, because, as you say, the precautionary principle is essentially saying if you can't be certain there won't be negative impacts, then taking a precautionary approach. In this case, we're looking at development and protecting sites, and therefore we should be looking to be taking measures to protect them unless we know that they definitely will not be impacted.
Jess, that's a fantastic tour, and it's a fantastic historical account, really, because many of these cases are now worthy of being called historical, given well into you started off in 1979. So thank you very much indeed for doing all of that work. You've produced a note as well, and that too is very generous of you, and I'm sure that listeners will want to have that to hand whenever they find themselves tackling these issues in whatever way they manifest themselves, whether it is the effects of what comes out of the back of a car, or whether it's the effect of somebody's cat, or, perish the thought, the effect of flushing the toilet. All of which seem to have been covered by you in this podcast. So thank you very much indeed.
Thank you very much for having me. Happy to help.
That was the planning podcast from No5 Chambers, with the second of our trio of How Did We Get Here? Next up is the High Court. Who pays and how much? It's a story that you need to understand if you're going to fully understand your position in a case where cost protection is in place. Make sure you watch out for when that next episode drops. Until then, goodbye.